by the state, you'll see that she found a 17 there as well, measured only by the length of the DNA strand. And what she's going to testify to is at this location and 5 or 6 others, there are alleles, all of which measure here 17, but actually contain different sequences. And that her testing that she used does not measure for those, especially as it relates to the comparison to Mr. Robinson.
Mr. McBride.
And she is also going to testify that the analysis she does is based on looking at the totality and all of the different markers that match and are consistent, and that's how she comes to the opinion that she does. The point is, there are explanations that are susceptible to different interpretations.
Whether it is applicable to the probable cause standard, I want to afford defense its full opportunity, but I still have to rein it in to keeping it to probable cause and not going into a full exploration, because that's not the purpose of a preliminary hearing. So I will admit Baker 34.
And isoalleles is a term used to refer to these alleles that have different sequence but the same length.
Correct, yes.
So across the top there for allele 17 and D3, there is a allele 17A, allele 17B, allele 17C.
Before this hearing even begins, it's important to understand why this exchange matters so much. On the surface, it sounds like a technical discussion about DNA charts, allele lengths, and laboratory testing methods. But underneath all of that scientific language is a much bigger legal battle that could dramatically affect the future of this case. Today, both sides are fighting over something courts deal with all the time. How much confidence should a judge place in scientific evidence before a trial even begins? The prosecution argues that the DNA analysis provides reliable support that a suspect could have contributed to the evidence. The defense, however, says there's a critical limitation hidden inside the testing itself. According to them, the laboratory only compared DNA strand lengths, not the underlying DNA sequences, and that distinction could make a significant difference when determining whether two samples are actually distinguishable. This isn't the final trial, and that's exactly why today's hearing becomes so fascinating. The judge isn't deciding guilt or innocence. Instead, the court is deciding whether the available evidence clears the much lower legal threshold known as probable cause. That difference is enormous because evidence that survives a preliminary hearing may later face much stricter scrutiny before a jury ever hears it. Watch carefully as both attorneys try to frame the exact same scientific evidence in completely different ways. One side insists the limitations go directly to reliability. The other argues those issues are simply questions for trial, not for today's hearing. Every objection, every exhibit, and every ruling carries consequences. As you watch, ask yourself this. If experts admit their testing cannot distinguish certain DNA sequence differences, would that make you question the strength of the evidence? Or is it still enough to establish probable cause? Let us know your thoughts as we follow every key moment of this courtroom battle.
So this chart illustrates what allele she found at each location for Mr. Twiggs and Mr. Robinson, and for the evidence samples, the 71A and 81A. The other alleles are on here as well, but we're going to focus on 71 and 81. And for instance, Your Honor, at the you'll see that under the first reading there is for Tyler Robinson at the D3 location. He is a 17. Okay, and take that down. And then if you go down to the 7-1 towel sample, which is what the topic is of this report introduced by the state, you'll see that she found a 17 there as well, measured only by the length of the DNA strand. And what she's going to testify to is at this location and 5 or 6 others, there are alleles, all of which measure here 17, but actually contain different sequences. And that her testing that she used does not measure for those differences.
And so as it relates to probable cause, that's what I want to keep coming back
Sure.
to. Again, if this was a trial, this may be a little bit different analysis
Yeah.
that the trial judge applies. But as a magistrate, taking a look at this and looking at the probable cause standard, how does this comport?
So it comports because it goes to the ultimate opinion expressed in the report that the state is offering, that the report offers reliable support that Mr. Robinson is a possible contributor. And we're asking the court to consider that the comparisons are only based on a limited number of length-based comparisons, and that there are sequence differences so that she cannot distinguish, and I believe she'll testify, she cannot distinguish based on the testing that she did in at least 5 separate locations, whether the evidence sample and Mr. Robinson's sample, or for that matter, Mr. Twig's sample, matches the sequence differences here. And this is my final area, and I think I can do it very efficiently, and I think it is important for the court to consider, especially as it relates to the comparison to Mr. Robinson.
Mr. McBride.
And she is also going to testify that the analysis she does is based on looking at the totality and all of the different markers that match and are consistent, and that's how she comes to the opinion that she does. The point is, there are explanations that are susceptible to different interpretations and arguments. Ultimately, we're going to have an expert hearing where all of the literature is going to be before the court, and the court's going to determine if it meets the threshold of reliability for admission at trial. But at this stage, even granting that there may be some argument that may come from defense counsel's position, the court can't weigh it. This does not go to the probable cause determination, and I don't think it's relevant, and this exhibit in particular is not relevant without the testimony of the witness, and so the exhibit should not be
This is
admitted on
one
its
of the
face.
first major turning points in the hearing. Notice how both attorneys are talking about reliability, but they're using that word in very different legal contexts. The defense wants the judge to focus on the scientific limitations of the DNA testing itself, arguing that if the testing cannot distinguish important sequence differences, then its conclusions should carry less weight. Meanwhile, the prosecution is reminding the court that today's proceeding isn't a full trial. Their position is that disputes over interpretation belong later, when experts can fully testify and be cross-examined before a fact finder. This distinction is incredibly important because probable cause is intentionally a much lower standard than proving guilt beyond a reasonable doubt. What do you think? Should judges closely examine scientific limitations at this stage, or simply determine whether enough evidence exists to move the case
And so
forward?
the exhibit should not be admitted on its face either.
That's why I was trying to lay a foundation that she would, and offered a proof to the court that she would testify, that in fact there are these sequence differences at the 5 or 6 locations, 6 different locations, relevant to the comparison to Mr. Robinson. And when the state says the court cannot weigh it, the court can weigh reliability. The court has ruled that. So we're simply asking the court to take into account the limited nature of these comparisons and the fact that she cannot, based on the testing that she performed, tell the court whether there are differences between, at these 5 locations. She can't match Mr. Robinson to the question samples because she didn't do sequence testing. And she'll also testify that the FBI is in the process of implementing this kind of testing.
All right. Thank you to both sides. I'm going to allow the admission of this evidence, but I'm also going to set a limit of a limited number of questions. We are now at 4:40. This is on the cusp of whether it is applicable to the probable cause standard. I want to afford defense its full opportunity, but I still have to rein it in to keeping it to probable cause and not going into a full exploration, because that's not the purpose of a preliminary hearing. So I will admit—
The judge has now made a decision that often happens in preliminary hearings but still carries significant consequences. Rather than excluding the evidence altogether, the court chooses to admit it while carefully limiting how much additional testimony will be allowed. That's a balancing act judges frequently have to perform. On one hand, the defense deserves an opportunity to challenge evidence they believe is flawed. On the other, the judge must prevent a preliminary hearing from turning into a full-scale trial complete with lengthy expert battles. Listen carefully over the next few minutes because even though questioning time is being restricted, the defense is clearly trying to preserve arguments that could become much more important later if this case proceeds to trial.
I will admit Baker 34, but Mr. Burt, I'm going to limit you to how much time do you need to address
I just
this?
need about 4 or 5 minutes. The next chart will be the chart with the, what are called isoalleles displayed for the court, so the court can see what we're talking about, and that's it.
All right.
I'm just going to have her document that, in fact, I've accurately stated what the alleles are that have sequence differences.
All right. So it is Mr. McBride.
Just on a second matter, which is I need to cross-examine this witness. She's got to leave town today. I would like 20 minutes to cross-examine the witness.
All right. Well, I will go with the I accept Mr. Burt's representations in the amount of time, and I'm going to talk less because that's consuming more time, and also allow the state the appropriate time for cross-examination given the nature of this witness having to travel. So, Mr. Burt, I'll turn to you. This has been moved into evidence. Do you want it on the screens?
Actually, I don't need it on the screen, just in the interest of efficiency. Pull up the next one, please.
Okay.
I want 35. Take that one down. And is this exhibit the same chart with what are called the isoalleles indicated?
Yes, it is.
And isoalleles is a term used to refer to these alleles that have different sequence but the same length.
Correct, yes.
So across the top there for allele 17 and D3, there is a allele 17A, allele 17B, allele 17C, all with the same length, but different sequences for each of those three.
Correct, yes.
And similarly at VWA, where you say that Mr. Robinson is an 1819 and 1819 in the evidence sample, there's an 18A, an 18B, a 19A, and a 19B.
Correct, yes.
And similarly for the other areas I've indicated there, I've accurately stated what the different sequence alleles are, correct?
Yes.
So I move this exhibit into evidence, Your Honor, and for publication.
Is this Baker 34?
Yes. 35. Baker 35.
Same objection, Your Honor.
All right. I'll admit it into evidence under the previous statement as it relates to Baker 34. It may be published.
And as you look at these 5 areas, you can't distinguish the evidence samples from Mr. Robinson based on the sequence differences, can you?
Correct. I only utilize length differences, STRs in this case. The FBI laboratory does not use sequencing for nuclear DNA testing, nor am I qualified in it.
Right. What is NGS?
NGS stands for Next Generation Sequencing.
And your laboratory is involved in validating next generation sequencing, correct?
We utilize next generation sequencing for mitochondrial DNA, which is a different subset of DNA testing, but not for nuclear DNA testing, which is what we're talking about today.
Now the questioning shifts toward the future of forensic science instead of just the testing performed in this particular case. The defense introduces next-generation sequencing, often called NGS, which can provide much more detailed DNA information than traditional length-based analysis. The witness acknowledges that this technology exists and that her laboratory uses it in other forms of DNA testing, but not for the type of nuclear DNA analysis involved here. That distinction matters because the defense appears to be suggesting that more advanced technology may someday answer questions that today's testing cannot. Of course, the key legal issue isn't whether newer science exists. It's whether the methods actually used in this investigation were sufficiently reliable under current standards. Do you believe courts should rely only on established testing methods? Or should emerging scientific advances influence how older evidence
Which is what
viewed?
we're talking about today.
Right. But the people who market STR mix also market a sequence platform, do they not?
I'm not aware if they do or do not.
This hearing ultimately centered on a highly technical, but extremely important question. How much weight should the court give DNA evidence when the testing method itself has acknowledged limitations? Throughout the proceeding, the defense emphasized that the laboratory relied on DNA length comparisons without sequencing certain genetic markers, arguing that this prevented the analyst from distinguishing important differences between samples. The prosecution countered that these scientific debates are matters for trial and do not prevent the evidence from satisfying the lower probable cause standard. In the end, the judge admitted the exhibits into evidence while limiting additional questioning, signaling that the court believed the evidence was appropriate for this stage of the case without deciding its ultimate credibility before a jury. As the litigation continues, these same scientific issues could become even more significant when experts are examined under the stricter standards required at trial. If you found this case as fascinating as we did, be sure to hit that like button, share your thoughts in the comments about whether you think the DNA evidence is persuasive, and don't forget to subscribe for more in-depth courtroom breakdowns, legal analysis, and the biggest developments from high-profile cases.